So this week, we got a very interesting preview of a very important case. Jack Smith's trial strategy in the federal indictment of Donald Trump's efforts to undermine the 2020 election. Last month, Trump's lawyers asked the judge in the case, Judge Tanya Chutkan, to dismiss language from the indictment that linked Trump to the violence of January 6th. And the special counsel's team responded to that this week, calling Trump's request a meritless effort to evade the indictment's clear allegations that the defendant is responsible for the events at the Capitol on January 6th. The defendant knew that the crowd that he had gathered in Washington for the certification was going to be angry. Despite this knowledge, or perhaps because of it, the defendant told knowing lies about the vice president's role in the congressional certification and directed the crowd to march to the Capitol and fight. The special counsel plans to join two narratives here. One, that Trump lied about election fraud, and two, that he incited violence as a last resort to stay in power. This is from Politico today. By combining the Trump allegations of election fraud with the riot, Jack Smith is unlocking a mountain of case law developed in the January 6th riot cases to tie Trump more clearly to the violence than he has been to date. In short, Smith is casting Trump as one of the 1,200-plus riot defendants who have already been charged. Joining me now is Mary McCord, former Assistant U.S. Attorney in Washington, D.C., and former Acting Assistant Attorney General for National Security. She is also, of course, the co-host of the MSNBC podcast, Prosecuting Donald Trump. Mary, it is great to see you tonight. We have not talked enough about the filings this week from the special counsel's office. This one, to me, seems very significant in that it ties all those 1,200-plus Jan 6 cases to the looming federal trial against Donald Trump on January 6 charges. Can you explain a little bit the significance of uniting those two, as they call it, mountains of case law?
Yeah, first I have to just say it's kind of funny to me how this has come up, because a motion to strike parts of an indictment is really kind of a silly motion. It isn't made very often. The indictment isn't even given to the jury. And whether the court strikes it or not, and I don't think the court will for all the reasons that Jack Smith argues, it's kind of meaningless when it comes to trial. What this may show is that Trump is planning to actually file a motion in limine to actually prohibit the introduction of the evidence that Jack Smith has now said in its response that he will be introducing. But I think, what we're seeing now is really just a further explanation of what was already in the indictment, right? The indictment showed that multi-pronged effort, beginning with the lies, the pressure on state legislators, the pressure on the fraudulent electors to meet, the pressure on Vice President Pence, the culmination with the riot, during which Trump himself added fuel to the fire. Remember, at 2:24, well into the riot, Trump tweets out that Mike Pence didn't have the courage to do what needed to be done, and the U.S. demands the truth. I'm looking down at the indictment. So already it did tie him to the violence, but here we're seeing exactly what the government says it intends to introduce, right? Video evidence, geolocation evidence, audio evidence, things to show the things that they argue are relevant, meaning they tend to prove evidence more probable than not and relevant. They are important to show the motive and intent of Donald Trump. Things that he did during the riot, things that he said after, shows he intended all along to obstruct that official proceeding. He intended all along for his conduct to result in overriding the will of the people, and that it provides important context as well for explaining the entire. Remember, he's charged with 3 different conspiracies. So I think it's a natural outgrowth of what was in the indictment, but we see it in sort of much greater detail as a preview of what the evidence will show at trial.
Yeah, there's a particular, when you talk about the evidence that Smith is planning to introduce that maybe Trump would like to see blocked, there's a particular part of it that I thought was intriguing. This is a quote from the government's response to Trump's motion. Testimony will establish that the defendant was informed of, though indifferent to, the fact that the vice president had to be evacuated from the Senate to a secure location. Although the defendant knew that the certification proceedings had been interrupted and suspended, he rejected multiple entreaties to calm the rioters and instead provoked them by publicly attacking the vice president. Mary, that sure sounds like someone has testified about what was happening in the West Wing or in the White House during the insurrection? What was going on with Donald Trump? It's kind of a black hole in terms of information. And my mind immediately went to Mark Meadows, who we know is cooperating or has talked to Jack Smith at least 3 times and has been granted immunity in all of this.
I mean, certainly this representation shows that the government believes it can prove up that Donald Trump was well aware of what was happening, not just based on watching the videos, you know, as we've heard from Cassidy Hutchinson, that he was watching video, or I should just say live television of the riots, but also that he was well aware of the evacuation of Mike Pence, as you say. And so they wouldn't be putting in there if they didn't have the proof. And I think, you know, your speculation that it's Meadows is probably as good as any, because certainly we know from Cassidy Hutchinson that he was in contact with the president, you know, throughout that day.
I do wonder, Mary, the prosecution would also like to know whether Trump is going to assert an advice of counsel defense, something we talked a little bit last night. But if he does assert that, then that entitles Jack Smith to even more evidence, does it not? Including correspondence between Trump and his lawyers, several of whom have already pleaded guilty down in Georgia.
That's right. And so, you know, as Judge Chutkan ruled when she said, I'm going to give you some more time before you have to give prior notice. The government wanted that notice in December. She says, I'm going to let it be in January. Trump himself has already argued, Trump's lawyers have already offered to provide notice in advance by January 15th, I believe is the day. She said, but I'm going to require that if he provides notice that he's going to rely on advice of counsel, because that waives attorney-client privilege, he has to at the same time disclose to the government all of the communications that he intends to rely on, communications with his lawyers that he intends to rely on to make that advice of counsel defense, as well as any communications that he doesn't intend to rely on, but that are relevant to it. So things that might detract from any advice of counsel defense. And the judge also discusses about how an advice of counsel defense, or the government in its briefing has discussed, requires that you disclose all pertinent facts to your lawyer when you're seeking advice, and then you rely on that advice in good faith. So it remains to be seen with this order and with the judge's ruling whether, in fact, that's a defense that the former president will decide to rely upon.